As per 19.6.
that as per order 96/2023, a consolidated petition is required by incorporate the newly impeded respondent. He prays for further 2 weeks time for the same. List of
Interim order passed earlier in connected cases to be called.
interim order, if any, can extended to the next date of 46 to
44 to 50, my lord.
contempt is there.
Contempt is there, my lord. Your lordship was pleased to draw form of contempt, my lord.
44 to
50.
Maybe. My lord, I'm paying for listing of 2 connected civil revision petitions, my lord, for orders, my lord, on Friday or Monday.
orders, right? What are the matter?
My lord has passed an order for filing an appropriate application for correction of the name of respondent number 1 in both the cases. I filed that application.
Oh, right.
May I please, your lordship. Lordship, I beg to mention item number 3 of the daily list.
Yes.
In this case, I'm being led by Mr. Kane Jyoti. He is out of station in Delhi. So can we list
I
it
don't
on
know,
4?
not 3, 4.
4, Lordship. Sorry.
Yes.
Item number 4.
You want some other day?
Monday, he'll be back by Friday.
A prayer for adjournment has been made by Sri R.J. Das, Attorney Counsel for the petition. Placed on Monday next.
4th.
4/10.
Deeply obliged.
May I please, the lordship, my lord, I pray for listing of a motion matter, CRP, my lord, on Wednesday, my lord. Oblige, my lord.
File or not?
Yes, my lord, already numbered.
I may like to mention for listing matter.
Listing
MSc matter.
Hmm?
MSc matter.
MSc. For what?
For admission matter.
Admission.
For admission or my lord disposal matter. 2018 matter.
18. Why for admission? Not admission.
And already admitted my lord.
Yeah.
Then my hearing my lord. For hearing my lord.
Hearing will not come by mention memo. Will come up for orders.
Order.
If for orders on Friday,
Okay.
we'll fix the date of hearing.
May I please, Lord? I beg to mention item number 25, Lordship. May I pray for agenda matter for a week, Lord?
25.
Lordship.
Have you informed the other side?
No, other side is not appeared, Lord.
25 government is there? Yes, government. Anybody from the government? 25 RDC, Vijay Bhushan.
Lordship.
Anyone from the government? 21,
Next week, Lordship.
your S.H. Rahman.
Lordship.
On the prayer of S.H. Rahman. Then it comes for the appellants. Please after the week.
Obliged, Lordship.
25.
My please, Lordship. Lordship, I beg to mention item number 6 and 24.
6 and
6 and
24.
24. Lordship.
Yes.
Lordship, the youngest senior counsel is hospitalized. Therefore, kindly fix it on
Who's the senior counsel?
R. Ali, Mr. R. Ali.
Alright.
Lordship. So kindly fix it on Lordship on Thursday.
Not his, if he's in the hospital, how can he come on Thursday?
He will be there, Lordship.
We'll have it on next Monday. Let me have some time. It is submitted. This court has been informed that Sri R. Ali, Learned Counsel for the petitioner, if the petition 6 or 24 May, he is unwell. List on Monday next.
Hello.
May appeal. Allag-allag.
May it please your lordship, I beg to mention for listing of an IA.
IA
come up
for?
for order. My lord, there is a stay where we were praying to withdraw the deposited amount. MSc appeal met
Okay, you're for the claimant.
claimant responded.
When do you want?
My lord, Wednesday must oblige.
May I please, lordship? Well, lordship, I beg to mention for listing one RS lordship for order.
RSA.
RS lordship.
Of which year?
Lordship 22 lordship. Lordship 120, lordship 29.
Orders for what? What purpose?
Lordship, this is the land dispute matter, lordship. Earlier, this I'm for the respondent. earlier the appeal and came to this high court. High court dismissed the petition and brought the remanded back the matter to the lawyer court. And lawyer court also dismissed the prayer again then come, again they will come the High Court.
And what is, why do you want for orders? What is the stage now? Appeal has been admitted.
Yes, Lordship, admitted.
You have appeared.
Yes, Lordship.
Matter of which year?
2022, Lordship.
22.
Yes, sir.
Year. Suit of which year?
Lordship, it was filed on 5/11/22, Lordship.
Suit of which year? Suit.
Lordship.
Come prepared.
May I please, your Lordship, Lordship, I am praying for listing of this RSA Lordship in the orders portal.
RS of which year? Why do you want?
16 Lordship, we have filed IA Lordship on 3
RS of 16, 2016.
Lordship.
Please, your lordship. I beg to mention item number 43 and 54, lord,
43 and 55.
and 54, lord,
Yes, and 54.
and 54.
Yes.
But the matter may be kindly passed over for the day,
You are mentioning on behalf of whom?
on behalf of our firm.
R. Sharma. Inform the other side.
Yes, sir. A prayer has been made on behalf of the R. Sharma, Senate Council for adjournment. When do you want? After a week? After 2 weeks, sir. His health is not well. Lord.
As he is unwell. As he stated to be unwell. Please, after. Alag, alag, huh?
Interim
40,
order earlier, lordship,
43,
43 and 54. Lord.
interim order is in which matter?
Both the matter.
In your favor?
Yes.
Interim order, first earlier, transaction next week. 44 and 43.
May I please, your Lordship? Lordship, I beg to mention listing of MAC Appeal 83/2023. Lordship, it was last listed on 15/3/2023. It's been a 6-month, Lordship. The matter has not come up.
Has it been admitted or
Yes, Lord.
admitted?
Yes.
Admitted on which date?
Same date only.
Which date? What was the date?
Lordship,
What was the date you had said?
15/3/2023. And it's been now 6 months.
Friday.
Deeply obliged.
Yeah, please, your lordship, I beg to mention item 21.
Yes.
Yes, for adjournment. My senior is having some personal difficulties, so
Who is
he's
your
not in the
senior?
court. Detail does. Lordship.
21.
Yes, lordship.
On a prayer made on behalf of the appellant, matter is adjourned by 1 week. By a week. Please, thereafter.
Obliged.
May I please, your Lordship. I beg to listing of one matter, your Lordship, FA 48/23.
23, new
yes.
matter.
On yes, your Lordship. On day after tomorrow.
When did you file?
I am for the respondent.
Now, why do you want this?
Appellant has obtained an interim order from this honorable court, your Lordship, and over the cultivation over a part of the scheduled land. But now
Have you
that,
filed any IA?
no, your Lordship.
If you want modification of the interim order, you need to file an IA.
No, they are trying to constructing over the entire land, your Lordship. So,
No, without there being an application from your side, seeking clarification, can we pass any orders? We can get it listed, but it will not serve your purpose. You file an IA, make a mention, we will allow. But what you have said that they have obtained an interim order
interim order.
and they are misusing the interim order.
Yes, your Lordship.
File an IA, bring it to the notice of the court.
May we please, Lordship, I beg for adjournment of item number 15.
1-5.
1/5.
Yes.
Because of some personal difficulties, the engaged advocate cannot.
Who's your senior?
S. Sahu.
When do you want? After 2 weeks?
Anytime, like Monday, next week. Or
Next week. On a prayer made on behalf of the Senate Council for the appellant, matter is adjourned by a week.
May I please? Lordship, I pray for listing a IA file in connection with MSc appeal number 923 of
IA
2018.
for
IA for your Lordship, keeping the Xerox copy of the LCR, your Lordship. LCR received by this honorable court due to which we are not, MSC not release the 50% amount of lordship. That's why.
Okay, we'll have it on Friday. But
Deeply.
have you filed or not?
File on lordship file on 16/8/2023 on Friday. Deeply.
May please, your lordship. Lordship, there is an employee compensation case filed by the insurance company. Now the payment here was the cleaner come conductor.
We are taking for disposal of the 2009 method.
Yes.
And the second one is also for 2010 post hearing.
Yes.
We'll do one thing, we'll finish up the motion, then we'll pick up. But immediately after the motion. Okay? Admissions can wait, but motion then talk.
Your lordship, in the meantime, I'll check the evidence.
Do it.
Obliged.
The matter may be passed off for the day with the conducted custody as well.
Sarkar, your Sarkar.
But basically, it is a transfer petition. Lord.
Transfer from what?
It is a transfer of a DV matter. Lord.
Of a
Of a DV case, Lordship.
DV case.
Pending in Hojai court. Lordship.
You are the husband.
I am the husband. Lord.
What are your grounds for transfer?
Lordship, the petitioner number 1 is working in a private farm in Amritsar. And his ailing father and mother has also been made party in the DV matter, who lives in Dibrugarh and they are aged. And they don't have any Lordship.
So number 1 is the husband.
Lordship. And 2 and 3 are the father and mother of petitioner.
Okay. DV instituted where?
Lordship,
Hojai.
Hojai. Judicial magistrate and number 5 at Hojai. Lord. We are in case number 186/23.
Okay. What are your grounds?
Lordship, my first ground is that the petitioner number 1 is working at Amritsar in a private farm. So it will not be convenient for him to go on every day at Hojai. Lord. Instead, he has a direct flight communication or else train communication from Amritsar to Guwahati. Lordship. And I am paying for transfer at Guwahati. Lordship. And second is that the father and mother who has been made party in this matter are elderly as well as retired persons. And they are also on the medication. Lordship, I attached the medical certificates. And they don't have any relatives in Hojai. Lordship. So it would be convenient for him, all of them to contest at Guwahati instead of Hojai.
Your convenience is not the factor. Will the Guwahati court have jurisdiction otherwise? Will the Guwahati court have jurisdiction? Where is your ancestral domicile? You are a resident of Dibrugarh.
Dibrugarh. But I am praying in Guwahati because so that respondent also can have the access to.
But will Guwahati court have any jurisdiction?
Lordship, if this honorable court transfer the matter.
No, there has to be some cause of action. Either you are staying or some cause of action has occurred only because it is convenient for you. Could it be a ground for transfer?
Lordship, I am.
What is the stage?
Lordship, on the last occasion,
What is the stage of the DV proceeding?
it is in the admission statement. Means they have just initiated the process. Sir. First date
You
has
have
been-
you have received the summons.
Yes, Lordship, I have appeared on the my.
You filed your written statement.
No, we have not filed attachment. We have sought time, Lordship, so that the outcome of the TP can be.
Let us see the nature of allegation.
Lordship. Lordship, paragraph number 2, Lordship.
Allegations are very serious.
Although, Lordship, the allegations which had been made in the review proceeding, like that, Lordship, we have been forcefully taken to Guwahati Medical College for some medication without our consent, Lordship. And also the medical
No,
documents.
those are matters of fact. We not go into the fact.
Right.
We want to see whether you have been able to make out a case for transfer. Matt is showing the inconvenience. You are the husband.
Right.
If the
And-
wife would have come, matter would have been slightly different.
Lordship, and the thing
For
is,
you to attend from Amritsar at Guwahati and to attend at Ahuja, it hardly makes any difference.
Lordship, the
From Guwahati to Ahuja, how long will it take?
Lordship, I agree that, Lordship, but the
3 hours maximum.
the petition number 2 and 3, Lordship, they are ailing couples, Lordship. They are staying at Dibrugarh, Lordship. So it will be inconvenient for them because they don't have any relatives at Ahuja, Lordship. Instead, they have relatives at Guwahati, and
From Dibrugarh, they can afford to come to Guwahati, but they cannot come to Ahuja.
Lordship, because
That's
they have
not
to
a
stay.
ground. If they are infirm old person, same difficulty will be there even for Guwahati. You are not seeking for Dibrugarh.
No, Lordship, actually, they come for medical purposes also in Guwahati, Lordship, because they are under medication in Guwahati also. So, Lordship, if it is transferred, Lordship, it would be convenient for Lordship. Lordship may not.
What are the age of your parents?
Lordship,
Where have you stated what are their age?
Lordship, the petition number 2, father is 69 years old and
Where?
mother is 6. Lordship,
Where have you stated?
in the page number 1,
It's number 1.
Lordship.
In the pleadings, you have not stated.
Lordship,
Page number 1 is cost title. Cost title is not verified in the affidavit. It has to form part of the pleadings.
Lordship.
It is only the pleadings which you have verified.
Lordship, I have annexed the medical document, sir. I have annexed the medical document, Lordship.
That
And
is okay, but you have to plead it because pleadings are verified.
Lordship.
Cost title is not verified.
Right.
You turn to your affidavit.
But I have highlighted in my plain that they are under medical treatment.
In the plaint, have you stated that this is 69 in the written statement?
Lordship, in the medical document also it is highlighted.
Medical document is a document.
Right.
When is the next date? What is it for?
Lordship, the next date is 11/10/23, Lord.
11/10
23
for
for WS, sir. And Lordship,
WS, you are not required to be present. Are you required to be present
Lordship, we are required to present.
physically?
Yes, sir.
All of you.
Lordship. In the last occasion, my counsel was present, Lordship, but at the court, before the landed court,
Magistrate.
Lordship,
Then?
they have pleaded that why the
Let us see the order. last order.
Lordship, I don't have that order.
Show that order.
Lordship, I'll place in the next.
Show that order that where physical presence is necessary. It can be dispensed with.
Lordship, in DV cases, generally the physical presence. of the-
Understood, but what's the stage? Stage is only of filing WS. You can file an application for dispensation. Do you know that there exists a provision for dispensation? And for accused it's much easier. For the complainant it's much difficult in a criminal case.
But Lordship, although for some,
You bring the copy of the order passed on the last occasion. There's the physical appearance direct.
the
I
order,
don't think we'll issue notice. But we're not going to say this.
Lordship, my only way is that the person concerned, or all the petitioners don't have any relatives in Hojai, Lordship. And if they go for the particular, that they have to
If that
stay.
is the consideration, all cases will have to be transferred.
And the second is that Lordship, although I have not mentioned my plain Lordship, the respondent belong from some, they are very influential persons, Lordship, and they have that's from them also. Although I have not stated this in the plain.
This transfer petition itself is that power is exercised only on very rare cases. You have to make out a definite case that this is the prejudice I am going to suffer if this matter is not transferred.
Lordship, for the
Can you serve trustee? Can you serve trustee? Oh.
Okay, Lordship.
To serve trustee, then we can fix this matter on a date prior to 11.
Lordship, if any interim prayer is given, Lordship, it
No,
will be.
not now. That is why we were saying that prior to the next date, we'll fix this matter. On their presence, we can may pass some order, but not today. We are not such. Third, the S Sarkar, Senate Council for the petitioners who have filed petition under section 24 of the Code of Civil Procedure, praying for transfer of the V case number 186 of 2023, which has been instituted in the Court of the Learned Judicial Magistrate First Class -5 Sankardev Nagar, Hojai. Is submitted that the petition number 1, who is the husband of the complainant, is employed at Amritsar, and the petition number 2 and 3, who are the parents of the petition number 1, are residents of Dibrugarh, and it would be wholly inconvenient for the petitioner to attend the proceedings at Hojai, and therefore prayed for its transfer to Guwahati, to an appropriate court at Guwahati. Issue notice written on next date is where? 11th.
10, 11.
10th of October.
11, 10, 23. Lordship.
11th.
11, 10.
11th to 9th. It's on 9th of October. 2 days. 9, 10, 20. That have to be taken for service of upon the sole responsibility by registered. Step is also permitted to be taken by means of the service, which, however, is routed through the registry of this court and in the notice, on the notice, accompanying justice from the next date clearly reflect. The petitioners are also required to file an in proof of such justice prior to the next. List, on the list on is directed above, on which the interim prayer may be.
I love.
Bora,
May I please your lordship? This revision petition filed against the judgment and decree passed by the Munshi Juhat and appeal the judgment and decree by the senior division criminal. Lordship, I challenge this is revision is only material defect and jurisdiction is not vested in law, lordship. Lordship,
what was good about?
Sure about the eviction to me, lordship, from one small shop, lordship. I am a tenant, but without default of payment and without any area and to be paid or any bona fide requirement, I have to notice. Lordship,
See, it is a confident finding of fact.
tax and
Now, if you come to a revisional court,
lordship.
you have to make out an exceptional case that there was error of jurisdiction or it is totally perverse.
Law also involved lordship. Only jurisdictional
What is the jurisdictional error?
but not material.
What is the jurisdictional error?
Jurisdictional error is lordship. There is only jurisdictional vested lordship, but not materially or all materially facts and lordship wrong lordship. Lordship may kindly page number 14 lordship. First notice was issued. There was not any demand, default or area payment or any bona fide requirement. Page number 14 lordship.
1-4.
1-4 lordship. Notice issued to me lordship.
Yes.
Annexure 1 lordship. Notice to the tenant for vacating the rental room lordship. There is no mention in any area of rent or any bona fide lordship. After that, I replied that notice lordship. After thought, they demanded area rent of rupees 34,000. Annexure 1 lordship.
Page
14 lordship.
14 we have seen.
Lordship. After that, we have replied lordship.
Yes.
Annexure 2 lordship.
Yes. 15 year
Lordship. After that, they demanded a 34,000 area rent. Although we have already paid and up to date rent lordship.
See, a notice cannot have so much of particulars.
Lordship.
If the particulars are there in the pane,
Right, lordship.
that is what is material for us.
Lordship. My
If
ground
it
is there,
and if they were able to prove it.
lordship. My ground is page number 9, lordship.
Now, in the pane, where is the ground of ejectment?
Ground is there, they only falsely required, they demanded that we have a need the room, small room lordship. We have a tea shop. This is owner already Juhat Municipality Board lordship. Allotted to me. Allotted that landlord and
Have they started the execution process?
lordship.
Started.
Lordship. No, not started lordship.
Will issue notice that
Issue notice and kindly lordship may stay
will not,
till the
will not, they have not started execution. Once they start, you can come.
Respondent number 1 lordship. Issue notice.
Third. They are put out an account for petition. Who has petitioners
No.
who have filed under section 115 of the Code of Civil Procedure. Challenging a judgment and order dated 9/8/2020 passed by the learned
Civil Judge.
Senior Division Jorhat entitled appeal number 3 of 2018, whereby the judgment and decree dated 20/12/2017 entitled number 5 of 2015 has been upheld and the appeal has been dismissed. Full stop. The suit was instituted by the plaintiff landlord for rejection. Full stop. Para. The learned counsel has submitted that both the judgments suffered from error of law and material facts were not taken into consideration. There are two notice returnable on on 16th of October. That steps to take for service of notice upon respondent.
One,
One and
and
two, both
both, sir.
of
One and
that
two.
by registered post state as well as by usual process. Registered step by tomorrow.
Master Lalit.
May I please? Lordship, an application, your Lordship, we have before this honorable court assailing an order dated 28/7/23 as annexure K, page 91 here.
Who are you?
I am the defendant in this suit, your Lordship. Now,
Petitioner is the defendant.
now, the sole defendant. Now, in this case, what had
Suit was
happened,
for
put for realization, it was a money suit, your Lordship.
understood.
Now, the plaintiff examined himself and other witnesses. My deposition was there as the defendant number, sole witness of the defendant, and I was cross-examined. Thereafter, an official witness was being examined. During the process of cross-examination of the official witness produced by me, the plaintiff files an application under Order 18, Rule 17, seeking re-examination of himself as PW1 and PW2.
There are two PW.
Three, I think, 4 PWs, of which
Four were there.
4 are there, your Lordship.
PW1 is that plaintiff.
Yes. Now, during the cross-examination of my official witness, when he was being cross-examined on the second day, the plaintiff files an application under Order 18, Rule 17, seeking re-examination of himself and the PW2, as well as calling for a new witness from the CGM court without disclosing the name. Now, that application was allowed by the trial court, allowing that thing. Now, we are before this honorable court on this ground that power under Order 18, Rule 17 is a power to be exercised by the court itself, your Lordship. It cannot be. And the application which they filed clearly says that this is being filed because PW1 and 2 failed to prove the documents which he had relied upon as per the Evidence Act. So this application is being filed.
No, but because we have just contended that this power is to exercise so much.
It is suo moto plus, because there are judgments of the apex
There are
court.
judgments where application, this power can be exercised on application.
It is application, but the apex court has laid down. This is akin to the power
And
of,
that is also at any stage of the,
it is to, means, if I may submit, it is akin to the power of under 165 of the Evidence Act, putting questions by the court. This cannot be a power by which cross-examination or re-examination of a witness is to be allowed by the trial court. And for that purpose, just if I may just place a, and because if your lordship sees the application on the basis of which this application, the order was passed.
Is this the only provision which the court had invoked?
Yes.
No other provision?
No other. Now, that
Now,
apart, your
let us see the application.
yes, the annexure J, your lordship, page 83. That is important because it clearly is transparent that they are using this thing to fill up the lacuna that exists in their evidence. If I may read out, your lordship, para 2. The plaintiff examined 4 numbers of witnesses in support of the case. The plaintiff examined himself as PW1 and exhibited documents, exhibit 1 to 6, the counterfoil of bank deposit slip, the original which was seized by the Dhubri police.
What is the decision you are trying to?
These were are photocopies of this. Then para 3.
What are the decision you are trying to? Because you may be correct in the re-examination is only for the court to ask questions.
Yes.
As of right, they cannot say that we are.
It cannot be a matter of right. And your para 3 of this clearly shows of the application says that it was your lordship in 2011. If your lordship takes up the judgment of 2009 for SCC, I will be placing reliance on para 25 of the same. Your lordship.
Right.
Yes, your lord.
That Vadiraj.
Yes. Has been interpreted to include applications for parties to recall witness. The main purpose of the rule is to enable the court which trying the suit to clarify any doubt which it may have with regard to the evidence led by the parties. The said provision are not intended to be used to fill up omission in the evidence of a witness who has already been examined. This is what I'm trying to emphasize upon your lordship. And similar view has been taken in the next judgment at
Just a minute.
the 2011 judgment, your lordship, para 9 and 10. 2011 judgment, your lordship, 2011-11 SCC 275. I will be placing reliance on para 9 and 10 of the thing. The last 4 lines of para 9 and 10, your lordship. The said power is, which is a repetition of what I had placed earlier judgment, that Order 18 Rule 17 is not a provision intended to enable the parties to recall any witness for the further examination in chief or cross-examination or to place additional material or evidence, which could not be produced when the evidence was being recorded. Order 18 Rule 17 is primarily a provision enabling the court to clarify any issue or doubt by recalling any witness, either suo motu or at the request of any party, so that the court itself who can put question and elicit answers. Once a witness is recalled for the purpose of that, may of course be, that is a different aspect. But what I'm trying to say, your lordship, a party cannot invoke this particular application to fill up lacuna because para 3 of their application clearly highlight the main objective of filing this application. Page 84, your lordship will see.
Yes.
That PW2 deputy such and such and PW3 also failed to prove the exhibit such and such in accordance with law. That the exhibit were proved under objection, failed to prove this. Has not in possession and control of the said of such and such. Now they say that because they have obtained the certified copy, they want to introduce this. Now it is a lacuna on their part because if they were not aware, they could have used the exercise the power of, there are various provisions of the CPC from which they could have called for the records from the Dhubri CGM court. Especially your lordship is aware with regard to the provision of Order 13 Rule 10, by which a court may be asked to call for records from the other court. They did not follow this. Now, when the final stage of my cross-examination is going on, they filed this application to cover up the lacunas which is there. And that apart, your lordship, cross-examination, re-examination is a power
which should be exercised immediately of the closing of the cross-examination of a particular witness. Now they have waited.
Now, where is the provision regarding re-exam?
Re-examination section 138 of the Evidence Act, Your Lordship.
So no, here also
There is no specific provision because that is the and in this application of 83, they have mentioned section 138 of the Evidence Act also.
If come to 18(4), recording of evidence,
Yes, sir.
18(4) subsection 2.
That is with the commercial suits, Your Lordship.
No, 18(4). Order 18, Rule 4.
Yes, sir.
Recording of evidence.
Yes, in every case, the examination.
And come to 2.
Yes, Your Lordship.
The evidence, cross-examination, re-examination.
Yes,
There is you cannot say that there is no provision for re-examination.
I'm saying that re-examination.
Under, you may be able to write in considering under 18 Rule 17, this is not allowed. But can you totally cut out the?
No, even a wrong provision, if Your Lordship.
That is exactly what you're trying to. There is another provision.
But the thing is, Your Lordship, awaiting, because re-examination, if I am not wrong, Your Lordship.
There is a provision. Order 23 maybe.
The only thing is section 138 of the Evidence Act is there, Your Lordship.
138 is not restricted only from questions from the court.
Yes.
Unlike the restricted powers under Order 18 Rule 17. Yes. They have invoked or rather named Order 18 Rule 17, but thereby itself will restrict the powers of the.
But Your Lordship, the names of those means it is a case of re-examination. And two things are there.
Issue notice that them heard 3A Biswas loaded counsel for the how many petitioners?
There is one
petition for the petition.
One
who has filed this application under Article 227 of the Constitution of India, challenging an order date 28/7/2023 passed by the learned civil judge
Senior Dubri in Miss with bracket J, case number 30 of 2023, arising out of money suit number 6 of 2015. The petitioner is the defendant in the case. Full stop. Para. The case of the petitioner that after completion of plaintiff witnesses, comma, the examination of the defendant witness was also over.
No, it
And
was
thereafter-
continuing. Yeah.
No. Cross of the official witness here
Yeah.
was over. Thereafter, the defendant had called for an official witness whose cross-examination was continuing. At that stage, the plaintiff had filed an application under order 18, Rule 7 for re-examination of the plaintiff witness of PW1 and PW2. Correct?
PW 1, 2, and an unknown witness.
And some other official witness who were not earlier examined. By referring provision of order 18, Rule 17, comma, it counsel for the petition as submitted that apart from the fact that such powers are exclusive given to the court, comma, it involves only the question to be put by the court, and he further submits that such question may be put only for clarification of such matter. He submits that the present order impugned is in violation of mandate of the state, and in support of his submission, comma, he has placed reliance upon case of Badiraj Nagappa reported 2009 410, where it has been laid down that the aforesaid powers under order in Rule 7 can be invoked only for clarification of any doubt and not intended to be used to fill up omissions in the evidence of a witness who has already been examined. He has also relied upon the case of K.K. Velusam reported in 2011, wherein the aforesaid provision has been reiterated, and it has been further been laid down that power is discretionary and should be used sparingly in appropriate cases. There are clear notice of motion be issued, returnable on 16th of October.
Problem.
That step we take for service of control response by registered post paid steps by tomorrow.
The proceedings may be serial.
The Mr. Council raised for an interim order after hearing and upon consideration of interpretation given by the Honorable Supreme Court on the provisions of Order 18-7, this court is of the opinion that interest of justice would be met if till the return date and interim order is passed. That according to this directive, that till the returnable date, the returnable date, further proceed in respect of Manipur number 7 that before pending the court of the civil judge, the native would remain paid.
Obliged.
Since this order has been passed ex parte, the respondents may come up modification after inspection for my friend.
Obliged. Lordship, my name may be shown because the call is
Call this to respect as granted counsel for the case.
obliged.
The petitioner was the petitioner is the plaintiff in the title suit so and so. Petitioner filed the plaintiff filed this suit, her suit against that defendant number 1 contested the suit by filing his written statement. Thereafter, subsequently filed his counterclaim.
You are the one.
I am plaintiff.
Petitioner is the plaintiff.
Plaintiff.
Suit for
Declaration.
of right to interest.
No, Lordship. Declaration and cancellation and injunction.
Cancellation of what?
Unregistered sale agreement.
Cancellation of unregistered sale.
Unregistered sale agreement.
Agreement
Agreement
and
and injunction.
okay. Then what?
Defendant number 1 contested the suit by filing his written statement, subsequently filed his counterclaim. Defendant number 2 and 3 jointly filed their written statements. As against the written statement, I could not file by
2 and 3
jointly filed their written statement.
joint petition.
Thereafter, I could not file my written statement within the time because
In
of
the
some-
counterclaim.
in the counter against the counterclaim. And actually, it is seen from the record that it was the case that the plaintiff's advocate did not conduct the case properly. She was suffering from her left leg was broken. He was giving some other applications, petitions. Ultimately, that was closed. My only submission, limited prayer before this honorable court, I may be allowed to file counterclaim on my written statement against the contract.
When was the counterclaim filed?
Counterclaim was
Which is the order by which it has been closed?
Lordship at page 53-56.
Order by which the opportunity has been closed.
Lordship.
53.
On the last date, plaintiff has filed a petition to allow her to submit her written statement against the counterclaim and to allow her to deposit rupees 700. Copy of the same was furnished to the other side, but the defendant did not turn up for hearing on petition. Today, the plaintiff has again prayed for another date to submit the same, right, petition number so and so. The defendant did not turn up for hearing. I have perused the case records. It is seen that right order dated 9/12/2022, the plaintiff was granted a last chance to submit written objections. It is written statement actually against the counterclaim with a cost of 700, and the suit was posted for objection. The counterclaim on 20/12/2022, but the plaintiff failed to submit the same as the said date, and the petition for the plaintiff praying for another date for filing objection was rejected. Further, the plaintiff has failed to show the justifiable cause for the same. Accordingly, petition number 451 so and so, 439 so and so is hereby rejected. The vehicle was purchased. It is a case of a vehicle. The vehicle was purchased. I have purchased this thing.
heard the became Senate Council for the petition who has filed this under Article 227 of the Constitution against ordered it 36 2015 by which the application of the petition to file written statement against counterclaim of the defendant number one has been rejected. The petitioner is the plaintiff in the pending suit which has been instituted for declaration from cancellation of unregistered sale agreement and for injunction. This case of the petition that the defendant number one had filed the petition, which was followed by a counter. Subsequent, the defendant number two had also filed a joint written statement. It is the case of the petition that due to various reasons, including certain injuries received by the plaintiff, the written statement against the counter could not be filed in time, and therefore the aforesaid application. Therefore, the application was filed for allowing some more time to file the written statement, which was rejected by the impugned order in 36. The Senate Makuta Mihiri Koran trial court of Mukti Kulia Bode passed by Senate Court of the Munsif Arm Kulia Bode Nogam in type Putnam 4 packet A against the order 4 of 20 by written upon 16th of October 2020 at step for service of on the response be taken by registered by. When is the next date?
Next, I can't tell you. I did not have contact. Till that time,
36 long time. What has happened there?
there are some notice about the respondent number 4, actual financer. Notice was issued. See what that the proper respondent did not appear all the time. Restep was taken.
You have not been able to make out a case for the at least the next
Lordship,
day-
with a cost, it may be allowed.
No, not without hearing them. Without hearing, can we allow something?
Let's see, say, we don't lady.
Understood, but without hearing the other side, can we
Lordship,
finally allow a prayer?
Lordship.
No, you have not been able to make out a case for stay. 2 year finding lacking, facts are lacking, next date is not known to you. This is the
Lordship, in that case, let it cover, short date may be given so that we can take steps early.
don't put the third of will it be possible for have it on 6th of October.
Lordship.
The prayer for interim order would be considered
Lordship.
on the next.
Lordship, may kindly pass over for the time being.
Lordship, order 1, rule 10 to order 6, rule 17 was rejected, Lordship. The impugn order is at page number 35, Annex 3.
What do you say, madam?
Lordship, I have my application for the amendment is at page number 31.
No, on the impugned order.
Yes, Lordship.
What are your
Lordship, my submission is that the proposed defendants, they have not filed any objection, Lordship. And on my application, they have rejected the prior. The Durham trial court had rejected my application,
No,
Lordship.
that cannot be a ground. If the
And
trial
Lordship,
court is
the,
otherwise satisfied, that this is an application where objection is not even required to be called for. But you may have some other grounds. What are your grounds?
Lordship, it will not change the nature and character of the suit, Lordship, because the suit of the plaintiff, the petitioner is already for partition and for declaration. So they are the residing on the western.
Madam,
then
your submissions is to be framed, or you have to project your submission in respect of the reasons shown in the order. Why are you going to changing of nature and character? What was the consideration of the learned judge? That no cause of
no
action has
cause of
arisen.
action is
What is your take on this? What do you say?
Lordship, my submission will
What
be
you are
that.
submitting is a general proposition on
Yes,
amendment.
yes, Lordship.
That was not the consideration for the judge. Learned judge has said that no cause of action has arisen.
Lordship,
What do you contend? How do you?
Lordship may kindly then come to page number 31, Lordship. That is my application, Lordship.
No,
Where
what
I
is the
have,
submission? We are not on the application.
Lordship, they
On
have,
legal submission, what is the legal submission?
they have tried to encroach, Lordship. They have tried to encroach over my plot of land, Lordship, and then they have tried to forcefully place pillars. So that itself shows that there is a cause of action, Lordship. Because the same thing, they can repeat it on future also if there is no legal binding.
No, madam, you are not hitting the point. Cause of action, will it only arise when the thing is actually done? Or it can arise even on the apprehension, which may be a genuine apprehension. You try to argue your point, make your arguments on this point. Will you wait for the erecting of pillars? Is it necessary? What is the meaning of this order is that you have to wait till the pillars are given, then only you have a cause of action. Can it be a reasonable interpretation? You have to make the arguments in that manner. If you can make out that a cause of action has indeed arisen because they have come here, and it is not a mere imagination that they may come. You have reasons which you have stated, and the learned judge has said that no cause of action has arisen. That finding may not be correct. You have to formulate your submission in that time. This rejection is not on the general proposition that will changing the nature and character, or at any stage the issues are framed. Those are not even the consideration. Let us see your application. You are trying to
Page
Please.
31, Lordship.
3-1.
31.
This suit is otherwise for what?
Partition and for declaration.
Declaration of
Right title and interest of the plaintiff.
who are the defendants there?
Defendants are the neighbors, Lordship.
And this particular defendant whom you are proposing to implead,
Yes, Lordship. They are the resident of the western boundary.
but will, even if we hold this to be a cause of action as arising, will it not be a separate, different matter, subject matter altogether? Your suit was for partition and declaration.
Partition and declaration.
Now it was against somebody. Now somebody else is trying to encroach into your property,
Lordship.
which is not connected with the earlier defense. Will it be, can it be decided the same suit?
Yes, Lordship, because this is a suit for partition, Lordship.
Now these defendants, they are not even connected. Are they connected? They are neighbors.
They are the neighbors, Lordship.
It is not for demarcation. Partition has a different meaning, demarcation has different. It's not a boundary dispute.
Lordship, that is the reason I have also prayed for an amendment of the pleadings, Lordship, as well as the prayer. That Lordship will find it page number 33.
That is it. Can you mix up all the cause of action in one suit?
Then Lordship, again, another suit will arise, Lordship.
This is a different cause of action altogether. It is not between the same parties. That the mandate of law will be there, that whatever, how many cause of action is between the same parties are involved in the same subject matter, there has to be one suit. This is a different party, different cause of action.
The prayer, Lordship, in the
Application. Okay, we'll issue notice at this stage.
Lordship.
MSF Ahmed, Senate Counsel for the petition, who by means of petition filed under Article 27 of the Constitution of India has put to challenge an order dated 17/7/2020 passed by the learned civil judge, Karimganj, in Miss Case number 106 of 2023, arising out of title suit number 54 of 2020. Full stop. The petitioner, who is the plaintiff, had filed an application under Order 1, Rule 10, within bracket 2, comma, Order 6, Rule 17, read with Section 1 of Code of Civil Procedure, which was rejected by impugned order dated 17/7/2023. The learned judge had held that no cause of action had arisen, and therefore there was no occasion to file such an application. To notice returnable by returnable on 17th of October. That step be taken for service of this upon the respondent by registered court post PKD. How many respondents, madam?
Yes, Lordship.
How many? 29 respondents.
29.
Within 3 days. Yes.
Deeply obliged.
May it please your lord. Lordship, the petitioner plaintiff has filed this commercial suit for realization of dues from the defendant and others. Lordship, after the summons were issued to the defendant respondent, they were granted ex parte order at page number 38, your lord.
The petitioner is the plaintiff.
Lordship. Now the respondents were the
Suit
defendant
for
realization of dues, your lord, and interest.
okay, then what happened?
Your lordship, after the summons were served upon the defendant number 1 and
Appeared.
6, they didn't appear. So an ex parte order was passed on 11
Defendant 1 and
1 and 6, the present respondent.
not appear. Ex parte.
Ex parte on 11/5/2022. Your
11/5/22.
Two.
Ex parte against them.
Lord.
D1 and D6.
Lordship, thereafter the other defendants, they appeared on 11/8/2023. Oh, sorry, 22, Lord.
Other defendants appeared.
Now, your lordship, all the defendants are part of the same company. The defendant number 1, that is the respondent number 1, is the main company, and the others are officials and directors. Lordship, thereafter, after expiry of 120 days, on 20/12/22, your lordship, the defendant number 1 and 6, they filed an application under Order 9, Rule 7
On when?
on 20/12/2022. Your
2012-22.
22.
Order 9 Rule 7
Lordship,
filed
Lord.
by D1 and D6.
lordship.
Then
That petition was allowed by the learned court below by the order dated 3/6/23.
Page?
Page 60.
Order 9 Rule 7 allowed.
Now, this order we have challenged in the present CRPA. Now, your lordship, after the PPC was amended by the Commercial Court Act, the maximum period is 120 days. That period expired on 26/8/2022, your lord, in respect of the present
26/8/22.
22,
120 days expired.
lordship.
Is this a suit in the nature of a commercial suit?
Lordship.
From where are you making,
Lordship.
from where are you making the submission?
Lordship, this is registered as commercial suit 24/22.
Let us see.
The plaint is at page number 20, your lordship.
Hmm.
We have filed our mediation, which report was real estate
Initially,
report was
it was registered as a money suit.
money suit. Thereafter, it was converted to the
Yes,
commercial.
from where are you making? I'm beyond.
Your lordship, that order I have not annexed, your lordship.
But subsequent documents, it has been shown as commercial.
Lordship.
24 of 2022.
Yes,
right?
Lord.
No, that order you ought to happen, but that doesn't make any difference because the subsequent documents are there.
Lordship. Yes. Yes.
Now, you said that this mandate of 120 days have
Expired, your lord.
expired, so there was no scope.
Lord. As per the amendment.
Now, what
That
is
is-
the stage?
Lordship, they have filed an application for under Order 7, Rule 10. So the main suit is kept in abeyance. It is for hearing on the Order 7, Rule 10 petition on 6/11 for return of claim.
Why return?
They say that the jurisdiction is in Arunachal Pradesh, not in. But we have supplied the spare parts for their equipments from Guwahati.
And what has happened? 710?
Lordship, that is for hearing it.
It is on the part of getting 710.
Yes.
This has remained like. When is the next?
6th of November. Yeah.
We'll have it before that. HTTF.
Lord.
Heard HTTF turn count for the petition. Which has filed petition under Article
27 of the Constitution of India being agreed by an order that 360 passed by the learned Chief Judge number 3, Kamrup, written by M. in Miss, written by J, is number 118 of 2020. Income commercial food number 24 of 2022. The petition is the plaintiff in connected suit which was instituted for realization of dues and interest. This suit, which was initiated, registered as Mansur number 87 of 2022, was subsequently converted into commercial foot number 24 of 2022 as per the amendment of the code. In the case of the petitioner that as the defendant number 1 and 6 did not appear in spite of summons being served, an order was passed on 11/5/2022 for proceeding party who are the state defendant numbers 1 and 6. So it is further submitted that all the defendants are connected as they are part of the same company, which is the defendant number 1. The state defendant numbers 1 and 6, however, had filed the application, filed an application on 20/12/2020 under Order 9, Rule 7, on which the impugned order has been passed. Full stop. The Chetia, the learned counsel for the petitioner has submitted that the period prescribed for such purpose is 120 days, which had expired on 26 8 2020, and therefore there was no scope for allowing the petition under Order 9 Rule 7 after the expiry of state period. This court has also been informed that in the meantime, the defendants have filed an application under Order 7 Rule 10 of the, for return of the claim on which the hearing which is under consideration. Issue notice return on 17th of October. That step be taken for service of notice upon the response by registered possibility step within 2 days.
Earlier.
May I please, your lordship?
Caveat, why caveat?
My lord, my learned hand is on caveat, my lord.
Why caveat?
My lord, this is the second round of civil review. But they
Second
have
round of
an application under 227, my lord. I am the wife, my lord. I had filed an application under section 24 for pendant life maintenance. That application was cited. The petitioner had come challenging that. The Honorable Court on consideration had directed that the maintenance amount be paid to me. There was no modification regarding the period from which the maintenance is to be paid. the learned trial court in its order, if I may just quickly take your lordship to the order for a moment.
Period.
See, it was decided that maintenance has to be made from the date of filing of the application. That is 2/11/2022. My lord, we had filed an application immediately after passing of the order by this honorable court. We had filed an application stating that there is this particular amount which is due payable with regard to the maintenance. Therein, the petitioner had filed an objection, which was registered as a petition, that he is only entitled to pay from the date of passing of the order of the honorable High Court. He had deposited for that month. Subsequent thereto, he did not deposit, and he has come again for challenging that order, that he is entitled to pay from the date of passing of the order by the honorable.
Lord,
Will discharge the caveat for?
Lord, I have
Will
a small,
discharge the caveat
my
for?
lord, my lord.
Or are you,
No, my lord, I have a small instruction from the petitioner.
that you
my
will
lord.
pay?
No, my lord, that the some divorce in the divorce proceeding, my lord, some settlement may have arrived, my lord. So therefore, my lord, I have the instruction. I do not know whether my learned friend has that instruction or not. So, my lord, only a short adjournment I am asking for, my lord.
So will they discharge the
Yes,
caveat?
yes, my lord, that can be.
Heard A. Bhatra, Senate Council, for the caveat which has been lodged in connection with an order dated 28/7/2023
My lord.
passed by the learned Additional District Judge Dibrugarh in Meet case number 37 of 2022, whereby the entitlement of maintenance pendency light
Right.
has been held to be from the date of institution
Of
Of
the
Filing
divorce.
of the
institution of the application.
24 application.
The whereas caveat would be heard in the event this court proposes to pass any interim order. So caveat can discharge.
Mal.
It means first 3 year we count for the petition, whereas the respondent is represented by Sri A. Bhatra, who has also filed a case. Sri Bhuya, the count, however, has submitted that as per instruction
Mal.
given to him, there may be a scope for out of court settlement
My lord.
of the entire matter,
My lord. In the yes, please.
entire matter,
That
and therefore he pays for a short adjournment. So,
weeks.
Sri Bhatra, the counsel for the respondent, however, submits that he does not have any such instruction.
Yes,
So, let this matter be adjourned.
Lord, the matter is fixed on 22nd.
No, it will
of this
proceed
month.
in
Doesn't matter,
accordance
we are not having any interim order. Adjourned, we decide after 2 weeks,
My lord.
fix the date,
Date may be fixed.
adjourned for 2 weeks, we decide on the
Third of
so
October.
we'll have it on 6th of October.
My lord.
We may be at liberty to file application to ask them to pay the.
No, that
We have
already
every
order,
market-
my lord, already
No,
order
change
is
order.
hanging on the my lord. My lord. Obliged.
If Mr. Bhuya's instructions is also transmitted to you, conveyed to you, right? That's the matter.
My lord,
Yes, yes, my lord.
no problem.
What is this?
Initially, I was a defendant.
Just a minute. Petitioner is the defendant.
Petitioner was the defendant. Petitioner filed a counterclaim. Counterclaim was decreed,
Your contracting.
and the suit was
Suit
dismissed.
was for what?
Suit was for right title interest, and the
Declaration
yes,
of right title interest. Petitioner defendant filed counterclaim.
counterclaim. Counterclaim was decreed.
Counterclaim was decreed, my lord.
Decreed.
Yes. Then they have preferred an appeal, my lord. The suit was initiated.
Plaintiff filed an appeal.
Yes, appeal. What happened during that time, the bifurcation of Kamrup district, the appeal was subsequently transferred to Amingaon. But the suit was filed before the Munsip number 4. Munsip number 4, the original suit was filed.
Here in Kamrup Metro.
Yes. Then
Court.
when first appeal was dismissed, they did not prefer any second appeal.
First appeal was for Amingaon.
Amingaon, civil judge. Initially, it was filed before the civil judge Kamrup. Then it was transferred to Amingaon.
Okay. Not bifurcation.
Yes, but due to bifurcation. The original record were kept in this Munsip number 1.
Thereafter, no second appeal.
No second appeal.
Appeal dismissed.
Appeal dismissed. We have preferred an execution proceeding before the Munsip number 1, where the original case record was kept. Before the Munsip number 1, where the original case record was kept. We preferred an cycle execution.
Case.
Yes, cycle execution 29 of 90.
Before Munsip number 1.
Before Munsip number 1.
Kamrup
Kamrup.
Metro.
Then I would like to draw your lordship attention to Annexure 6, page 22.
Yes.
Page 22.
Case 22.
Page 20.
What happened thereafter?
The Munsip number said that the case it was filed before the civil Munsip number 4, the civil junior division number 4. So the execution was to be filed before the appropriate court, and the execution was returned. Thereafter, we preferred an application before the Munsip number 4.
Yes.
On Munsip number 4, on 27/3/23, page 29, Annexure E.
29.
Page 29, Annexure E. Second last page. May I read the order? Okay. May I read the order?
27.3.
27/3.
Yes, please.
When we have filed an application, petitioner decree holder has filed a petition number substances under 151 CPC stating that title execution 29/19, which was pending for disposal before Honorable Munsip number 1, Kamrup, and the said execution case was returned to be filed before the appropriate court of jurisdiction by order dated such and such, that P7/2/2023. Learned counsel for the petitioner decree holder has submitted a copy of order dated such and such and of Munsip number 1. Peruse the same. By the said petition, learned counsel for the decree holder has called for the records.
That we have read.
Thereafter, my petition has been dismissed. Said that I don't have any jurisdiction to call for the record from Munsip number 1.
On 2/8.
On 2/8. That is the impugn order. And here it is mentioned that parties are liberty to approach proper forum if any. Only ground that the Munsip number 4 doesn't have any jurisdiction to call for the record from Munsip number 1. This is a total jurisdictional error, my lord, committed by the Munsip number 4, my lord, by deciding my
When the matter was sent to this particular court by the Munsip number 1, Thereafter, why this question of jurisdiction arise?
That is just a jurisdictional error committed by the municipal office.
It's not a question of calling for the record. He has already been, matter was clarified that it is his court. to take
Yes,
up the-
yes. Thereafter also my application has been-
Rejecting on some other grounds is a different
Yes,
matter.
yes. On jurisdiction point, it cannot be.
Please, Siraj, is certain grounds for petition who has filed under Article 7 of the Constitution of India, whereby he has challenged and ordered it. The orders, you are agreed by the second order.
Second order, second order.
Ordered it 2820 passed by the London Civil Judge Junior Division Court number in section number
That was registered as 13623 mistake.
was it a mistake?
Yeah, it was registered as mistake.
In mistake is number
136.
136 of 20. The petitioner was the defendant in a writing suit which was filed filed before court of the Muslim, Kanpur, which at which at that time was an which was before the bifurcation of the judicial district. No, bifurcation of the district. The suit was transmitted
The
to the
suit was decreed, my lord, here in the Munsib number 4. It was appealed.
to test Muslim number 4. Filed before Muslim number 1. The suit was heard by the Muslim number 4. Kamrup. In which the petitioner as defendant had filed a counterclaim. While the suit was dismissed, the counterclaim was decreed. In the meantime, there was bifurcation of the district and the state order by which the counterclaim was decreed was unsuccessful assailed by the plaintiff by filing an appeal before appellate court at Amangaon. There is no further appeal preferred, and therefore the decree in favor of petition had attained final. There are since the records were before the court of the number 1 Kamrup M from an execution case was by the petition. The learned court of Muslim number 1 Kamrup M had passed an order 7/2/20 whereby it was observed that since the case was before Muslim number 4, the execution petition was returned to be filed for the appropriate court of execution, which according to the petitioner had done. The learned court of the Muslim number 4, however, by the Muslim number 4, currently designated as junior division of bracket close. However, by the order 2820 had refused to entertain the petition by observing that the court did not have issue notice returnable by 4 weeks. That step we take for service of upon sole response by Richard Possibility, 754.
Developer.
May I please, Your Lord? My lord, the brief fact of the case is that plaintiff, my lord, as defendant, they filed a title suit being before the Munship number 1 Tinsukia.
Just your father, sir.
My lord. Petitioner is the respondent in the original title suit.
Defendant.
Defendant.
Suit for
My lord, declaration, eviction, recovery of first possession and permanent injunction.
by a landlord.
My lord?
Landlord.
No, my lord. He is the owner, my lord. Landowner. Landlord, my lord.
Landlord. Suit for ejectment.
My lord. Suit for ejection.
You are the tenant.
We are the defendant, my lord.
Tenant.
No, my lord. We are in possession, my lord.
You
We are not the
you
tenant.
deny that there was any tenancy agreement.
No, my lord.
You deny it.
Deny.
Then what happened?
Then, my lord, we have appeared. We have filed a written statement, my lord. Thereafter, issues were framed, and then matter was fixed for pending evidence file. Thereafter, my lord, on 9/12/22, my lord. 9/12/22, my lord.
Yes.
The defendant, my lord, plaintiff, my lord, he filed an evidence on affidavit as PW1, my lord. And he sought time to file evidence on affidavit of the other listed witness file. On the next date, my lord, he filed a petition, my lord, under the trial court and first appellate subordinate court case management rule, my lord, praying for cross-examination of PW1 first, and then he will file evidence in chief of other witnesses. Against which, my lord, we had filed objection, my lord.
When was that file application?
The application, my lord, it was filed on 17/1/23, my lord. That is, your lordship will find it annexure 4, my lord.
Application to first
Cross-examination of PW1 should be taken up, my lord.
and
then thereafter, my lord, he will file the evidence on affidavit of the other listed witnesses.
you file objection.
We have filed objection against that petition, my lord. And by order dated, my lord, 21/6/23, my lord, the learned Munship number 1 has allowed the petition of the plaintiff, my lord. Against that order, my lord, we have preferred this revision.
Yes. What are your grounds?
Ground, my lord, lordship will. Firstly, my lord, my prayer is that, my lord, the appreciation of the trial court management rule, my lord, that has been wrong interpretation has been done, my lord.
Trial court management.
My lord, it has been annexed, my lord, in the petition, my lord.
Okay. Page.
Page your lordship will find at page 43, my lord, annexure 6, my lord.
Okay.
And the relevant portion your lordship will find page 47, my lord, rule 6, my lord. Rule 6, my lord,
Page
47, my lord.
Yes.
Page 47, rule 6, my lord. Rule 6, your lordship will find then third para in rule 6, my lord. If the parties are not keen about settlement, my lord. Lordship, got it, my lord? If the parties are not keen about settlement, the court shall frame the issues and direct the plaintiff to start examining his witnesses. The procedure of each witness filing his examination in chief and being examined in cross or re-examination will continue one after the another. After completion of evidence on the plaintiff side, the defendant shall lead evidence likewise, witness after witness. In the chief examination of each witness being by affidavit and the witness being then cross-examined or re-examined. The parties shall keep the affidavit in chief examination ready whenever the witness examination is taken up. Here, my lord, they have relied on the one after the another. My lord. On this point, my lord, they have submitted that each examination of witness, my lord, they will file affidavit on each witness, my lord, and cross-examination will taken.
Yes,
Will taken up.
what's the submission?
My submission is that, my lord,
Why is this interpretation erroneous?
because, my lord, this will enable the petitioner, my lord, the plaintiff to fill up his Lucana, my lord.
No, no, there
Any
are,
defect-
there are interpretations. Earlier.
My lord,
How do you interpret this? If you are saying that this interpretation is an erroneous interpretation,
my lord,
we may agree upon it, but you have to convey.
my lord, here, my lord, your lordship will find the parties shall, rule 6, my lord,
Yes.
there are clearly stated, the parties shall
We
keep
have
the-
read, we have rule 6. The interpretation you say is erroneous. Why?
my here, my lord, your lordship will find the parties shall keep the affidavit in chief examination
There-
ready
there are-
whenever.
Mr. Parasa, there are case laws. How you have to present your evidence. Yes, there are case laws. Have you got a case law?
Yes, so, my lord, I have not submitted, my lord, but my, but the,
You have come to this court assailing an order. You have to make out
my lord,
your
No,
submission
even-
has to be based on something.
yes, my lord, even in CPC, my lord, this is, my lord, this is another rule 18, my lord. Rule 18, my lord, your lordship will find. Rule 18, my lord.
Yes.
Order 18, my lord. Rule 2, my lord. Statement and production of evidence, my lord.
Yes.
On the day fixed for the hearing of the suit or any other day to which the hearing, the party is having the right to begin, shall state his case and produce his evidence in support of his issues, my lord. Now, my lord, produce his evidence, my lord.
You're reading what?
My lord, order 18, my lord. Rule 2, my lord.
18.2.
Rule 2.1, my lord. The party having the right to begin shall state his case and produce his evidence in support of the issues which is bound to prove, my lord. My lord, evidence, my lord, he has to produce all his evidence, my lord. Then answer under rule 4, my lord. Recording of evidence, my lord. In every case, the examination chief of a witness shall be on affidavit and copies thereof shall be supplied to the opposite party by the party who calls in for evidence. Even then this 1A is that is for commercial issues, but here 1A is it is clearly stated, my lord.
You have the evidence there,
Yes, my lord.
138.
130 is missed.
After
Order of examination.
after definition of examination in chief and cross examination, re-examination,
Order of
in 38, 138, order of examination there, please read. Witnesses,
witnesses shall be first examined in chief, then cross-examined,
witnesses
my lord.
will first be examined in chief.
My lord.
That means their examination, their evidence has to be on the court, presented to the court first.
Yes.
Then only the order, it is the order of examination. And this has been interpreted in a number of
Right.
cases. Because unlike earlier times when oral examination was there, then the scope was there. But now that scope is gone. You cannot fill up the lecture or cannot improve the case by other witnesses. Your version has to be consistent, presented at the first person, then one after one, prosecutor. But there are case laws, you are not equipped.
My lord, regarding my lord trial case management system, my lord, there is a judgment of this honorable High Court, my lord. Similarly, my lord, similar situation, my lord.
What has been said?
Here, my lord, here it is stated, my lord, that
In the context of what?
in the context, my lord, here, my lord, another witness was thought to be examined, my lord, after additional evidence by additional evidence. Against that, this judgment was passed, my lord. Lordship may kindly see.
What has
Well, here, my lord, it is stated, my lord. I consider this submission advance learned counsel for both the parties and also prayer for correction of the order that the plaintiff cannot be permitted to adduce evidence of PW truth since the same would allow them to twist and complicate the subject matter of dispute after having to come to know about the stand of the defendants during the cross examination of PW 1 and 2. Here in this case, my lord, after cross examination of PW 1 and 2, my lord.
request for us to confirm for the petition who has filed under Article 227 of the Constitution in order 21(6) because the third concept number 1 comma in title number 120 of the petition is the defense the suit which has been filed for eviction. The defendant, the petitioner had filed the petitioner eviction in which written statement has been filed. On 9/12/22, the evidence on affidavit was presented by the PW1 and time was sought for filing the chief examination of the other PW. On 17/1/2023, the plaintiff had filed an application to have the cross-examination of the PW1 and then to present the chief examination of the other PW. The said application was objected to by petitioner by filing. However, by order dated 21/2023, the learned trial court had allowed the aforesaid while doing so, record has been taken to the trial court and it so in the rules of 2007. Comma, more particularly, Rule 6 thereof. Thereof. The Internet Council for the petitioner has submitted that the interpretation given on the aforesaid Rule 6 is an erroneous interpretation, and the same would be against the very essence of holding a trial. It is submitted that if the interpretation given is sustained, there will affect a fair trial whereby prejudice would be caused to the adverse party, as inasmuch as upon cross-examination the case which would be the projection of the adverse party would be exposed, giving a chance to fill up the economy. This court has also noticed that under section 138 of Indian Evidence Act 2, which based on order of accepting, it has been stated that witnesses shall be first examined in witness and then, if desired, be cross-examined. That is returnable by 4 weeks. Let them take for service of upon respondent by registered with 80 steps by tomorrow. Parasar Council petitioner pays for an interim order. What is the stage
My lord, next date is fixed on 11/10 for cross-examination.
of the other witness?
My lord.
Concept, facts and circumstances. That interest of justice would serve the further purpose. Facts and circumstances is case according to the next returnable date of further proceedings is suspended of that this order to pass, but the respondent could be able to come up for pass already it out of the reasonable on we'll have it on 13th of
Obligement.
Lordship, may I please write item number 44 to 50, my lord. Petitioner concerning item number 45, they, without informing us, my lord, they have adjourned the matter, my lord.
We had informed the head sir that your Mr. Das, junior of Mr. Das was informed.
They did not inform us, madam. Finally, matter we fixed on Friday, my lord. Matter is very
We had
urgent.
specifically asked. We had specifically asked Mr. T.I. Porpia. Where is he? Call him.
May it be done. Here I am the, originally I was the plaintiff.
Plaintiff. Yeah.
Originally I was the plaintiff, suit was dismissed. Then on appeal, it was remanded back. On remand,
Petitioner plaintiff to dismiss. Suit for what?
suit for declaration. For declaration,
Right title.
for possessory right, my lord.
Sorry.
Then on remand,
Suit was dismissed.
suit was initially dismissed. Then
You
we
filed an appeal.
appeal. On appeal, it was remanded back.
Allowed, remanded
Remanded back. On remand, suit was decreed.
in your favor.
Yes. Then respondent went for appeal, my lord, before the civil judge number 3. The title appeal was filed on 2017
Title appeal
by the respondent,
by defendant.
defendant. It was filed before the civil judge number 3. Numbered as title appeal 51/17.
Civil judge number 3 where? Kamrup.
Kamrup.
Title appeal number
51/17
51 67 by defendant.
by defendant.
Okay.
My lord, they did not take steps, my lord, on the present petitioner, my lord. On ultimately, my lord, on 4/5/2019, civil judge directed the respondent to took steps upon the counsel for the petitioner who appeared before the court in trial court. Had order dated 4/5/2019.
On counsel, earlier counsel.
Earlier counsel who appeared in the trial.
Okay.
And it was fixed on, next date was fixed on 25/7/2019. Then counsel accepted the notice and tried to make contact with the respondent, petitioner. They were on that time, my lord, on 2019, they were in Bihar. Petitioner were in Bihar. So they came back, and accordingly on 25/7/2019, when the case was fixed, my lord,
Yes.
they have filed an application. It is a cross objection. Filed and cross objection with a
Who?
limitation by the petitioner
In the appeal.
in the appeal. In the appeal, the cross objection with a limitation prayer, my lord, because the duration is 30 days from the
Which are prayer for condemnation.
condemnation of this. That was
Yes.
filed on 25/7/2019, when the date was fixed by the
With delay condemnation.
delay condemnation along with the cross objection. Ultimately, my lord, civil judge, my lord, dismissed my application, my lord, delay condemnation application. That is the impugn order, page E27.
27.
Page
27.3.
That is page number 27. Yes, 27/3/23. That is the impugn.
Yes.
Here it was held, my lord, I could not explain the delay of 51 days. Whereas I have filed an application, the day fixed, that fixed by the appellate court, my lord. That is my application. Annexure B, page 15. And next will be page 15, that was 25/7/2019. 25/7/2019, that is the date fixed by the appellate court. On that day, we have filed the application for cross-examination along with the delay condemnation application. The court has rejected, my lord, that I could not explain the delay of 51 days.
Yes, thereafter you have to challenge it.
Yes, before your lordship.
227 will be maintained.
Yes. Because order 43 doesn't provide any appeal from order 41 rule 22 application. Not dismissed. My order for 41 rule 22 application was dismissed. Order 22, order 41 rule 22.
Order 41 rule
22. Any respondent, though he may not have appeal from any part of the decree, may not only support the decree, but may also state that the finding against him in the court below in respect of any issue ought to have been in his favor, and may also take any cross objection. That is the cross objection. File such objection in the appellate court within 1 month from the date of service on him or his pleader of notice of any day fixed hearing the appeal, or within such further time as the appellate court may fit and allow. So I have filed the application within time as the date fixed by the appellate court.
that part, if you're only on the question whether
Then, my lord, order 43, where my lord appeal from orders, where it is shown, my lord, order 43. That was the list, my lord, order 43, rule 1, where from order it was as T is the order refusal under order 19, rule 41, 19 and 41.
and 21 of
Yeah, but not on 22. 20.
three, that is the Senate count for petition. But I'll under the principle of the Constitution of India against an order dated 27/3/2020 passed by the Learned Civil Judge number Kamrup M in Meet case number 600 of 2009 arising out of title appeal number 51 of 2007 to submit the petitioner was plaintiff in the original suit which was filed for declaration of possessory right. The suit was dismissed, which however was interfered with by the first appellate court, and the matter was remanded. On such remand, the suit was decreed in favor of the petitioner plaintiff, against which
comma, the other, the opposite party had preferred title appeal 51 of 2017 in the Court of Civil Judge number 3, Kamrup M. Full stop. Since steps were not taken, comma, by order dated 4/5/2009, since steps were not taken and the opposite parties could not be served, comma, an order by order dated 4/5/2019, comma, the learned court had directed taking of steps upon the learned counsel who had appeared for the party in the trial court. Full stop. The learned counsel had accordingly accepted notice, and since the petitioner were at Bihar at that point of time, comma, there was some delay in getting the necessary instructions, and ultimately on 29/5/2019, comma, a cross objection was filed. Full stop. Since there was some delay, comma, the cross objection was accompanied by a petition under Section 5 of the Petition Act for condonation of delay. Full stop. The said petition was registered as Miss J case number 2921 of 2019.
Meche case number 600.
Huh?
600.
600.
600.
600 of 2019.
Meche case number. That was the petition number. The case number was 600. Meche case number was 600.
Meche case number 600, which has however been by the impute order dated 27/3/2020. The London Council has submitted that a hypertechnical view has been taken by the London Court, and the delay of 51 days
51 days.
being properly explained from the same should have been accepted, and according to the cross objection re-entered. The Senate Council has also said that there is no provision for it in case of rejection of a cross objection, and therefore it can be by input Article 27. That notice is returnable on 3rd of October. That step taken for 3rd of upon responded by registered post steps by what kind of interim order do you want?
Stay of the title appeal, because it is necessary, because otherwise my appeal will be
Still the Senate Council is for the interim, considering facts and circumstances. Direct that will return a page of further procedure at that number 51 of 2007. Pending court turn it civil judge senior number Kamrup shall remain case. Since this order has been passed expert, comma,
respondent could get referred to come up with application notification of intent.
Deeply applied.
My lord, I was called.
Yes, you have not taken consent.
No, my lord, I had a talk with him, my lord,
Oh,
some
very good.
Hazarika. He said, my lord, there is no coordination between senior junior. I showed him the call detail.
Where is it? Please have it. So we not
No, my lord,
resolve matters without consent.
I have taken
No, he
consent.
had made a specific allegation. Call him.
My lord, I'm calling right now.
Mr. I think his name is Das.
Some Hazarika, my lord, I
Please have-
there is no coordination between senior junior.
You are Mr. Medhi.
Yes, ma'am.
Yes, yes, sir. He says that he has
I have shown him the call details. Also.
Lordship, my senior did not inform.
he has informed one count. That is enough.
Hmm.
And you are making a serious allegation. Consent was not. Who was informed? Who was informed?
Lordship,
Who amongst the council in your side was informed? Was anybody informed or not?
no, my lord.
To senior, I made a call, my lord. I made a call. I talked to him over phone, my lord. I right now also I got that.
Mr.
detail.
Das,
Yes, senior counsel Diganta Das.
make any statement. Have specific consent to-
Yes, my lord.
Have you asked your senior?
Not yet, ma'am.
Why not? Why did you urge it to the court that consent was not? Didn't you think that it was the duty to have a talk with the senior? Because once some council makes a statement, we believe it. And if you make an allegation, these are just allegations.
My lord, I got
At
that.
least making a
Proof also, I
report,
showed it.
allegation. Talk to your senior, then you come. And if your allegations are correct, perhaps you would have imposed cost upon
Lordship, as the
Mr.
matter is very urgent, my lord, therefore.
That is a different matter.
Lordship.
He has taken consent and consent to have H1B matter. Your urgency is not material. If you have consented.
Sorry, ma'am. Please, your lordship.
Yes, what is this?
Your lordship, this is the employees compensation case.
Okay.
The
Employees compensation.
injured. The injured was a conductor, is a conductor cum cleaner. He was employed
This
in,
is the appeal by whom?
appealed by the insurance company.
Appeal by insurance company.
Yes.
Okay. Under WC Act.
Under WC Act.
Okay. There, what happened?
Then your lordship,
There was a claim.
there was a claim.
Some death had occurred.
Not death, the
Injury.
claim, yes, he was
Injured was a conductor.
He was a cleaner cum conductor.
He was the claimant.
He was the claimant,
Claimant was inner some.
conductor.
Okay.
Then he sustained injuries. The primary injury was fracture of radius of right hand.
Fracture of
Radius of
What?
right hand.
what is radius?
There is a bone in the this bone, the forearm bone.
Okay.
Now the doctor, he assessed the disability at 20%, and due to the disability, the loss of earning capacity, he assessed it at 25%.
Disability is 20%.
20%,
Loss of earning capacity,
25%.
okay.
Now, taking the loss of earning capacity at 25%,
Yes.
the learned commissioner has awarded an amount of 1,31,040.
31,000 zero,
040. 131,040,
okay.
along with 12% interest from the date of order. Now, the substantial question, it was framed. One substantial question was framed. I think the order should be 25,
Yes,
2009.
so correct.
The substantial question was whether learned commissioner acted illegally in discarding the evidence of the owner that the injured, the claimant was not his employee and even he does not know him. Therefore, taking into consideration, the claimant is constituted to be the employee under him. So he has specifically denied in his, submitted his depositions also, that he has
The
denied that,
owner has denied.
yes, the owner has denied that he does not even know him. And the written statement was also not signed by him. Now, that part of the thing was not considered by the learned
Written
commissioner.
statement of whom?
Written statement of the owner. The judgment shows that one written statement was filed by the owner. Yes, the OP number 1, Sri Shashi Datta, filed his written statement admitting the employment of the claimant.
Where page
Page 7.
of the judgment?
Yes. Shashi Datta filed
Where? Which part?
the second para, page 7, second para.
On the other hand,
No, the OP number 1, internal page 3. 7 is the running page number.
no, just
Judgment internal page is 3.
3.
Yes.
Second para.
Yes, OP
Third
number
para.
1.
OP number 1.
OP number 1. Sri Shashi Datta filed his WS admitting the employment of the claimant. Now, your lordship may turn to page 5.
5. Yes.
Yes, that is the deposition. 1 to 3rd para, DW1. DW1 is the owner. Was cross-examined by both the learned advocate for the claimant and this court. In replies to the cross questions by the claimant.
Page 5.
Page 5. Yes.
PW2.
DW1. Second para, I may start from second para. DW1.
Second para, page 5 starts with the PW to Dr. Hazarika of the judgment.
Judgment. Then 1, 2. Then another two para. Your lordship may skip.
Yes.
Then
On closer.
yes. On after the on closure para, DW1. Your lordship.
PW1. Yes.
Yes. Shashi Datta, son of late so and so, resident of so and so, deposed that he owned the vehicle number so and so, which used to ply from Diffu to Nagaon Road. He had sold the vehicle at the time of his deposition. He admitted the occurrence of the of his above vehicle in 2005, but the claimant Satindra Kalwar was not in his employment in that vehicle at the time of accident, and he did not know the claimant. He specifically denied.
Yes.
He stated further that on receipt of the notice from the court, he contacted the insurer at Diffu and submitted the relevant papers. Thereafter, he did not make any contact with this court. He denied submission of his written statement marked as Exhibit A. Exhibit A1 is also not his signature. He came to the court on receipt of summons and he filed his hazira in Exhibit B and B1 is his signature. Now, DW1 was cross-examined by both the learned advocate for the claimant and this court. In replies to the cross questions by claimant's advocate, DW1 admitted that he could not remember the exact date of the accident of his above vehicle at Mori Kolom. At the time of the accident, his vehicle was driven by one Dimbester Wari and one Babu was the handyman. Here, one Satindra Kalwar is the handyman, which he has said that he do not know. He has stated that one Babu was the handyman. He denied that he had informed the police about the injuries of Satindra Kalwar as mentioned in the GT entry. He also stated that he does not sign any document in English. He denied to have filed the Exhibit 7, a petition filed before this court, stating that the claimant was neither an injured passenger nor an employee of the bus at the time of accident on 8/11/2005. He stated that he could not file any ID card, PAN card, or certificate from his association to prove his identity as Sati Datta. So, therefore, by his deposition, he has denied that this claimant is his employee. And this evidence was not considered.
How much is the amount?
Amount is 1,31,131. 131. But your lordship will see the FIR also. That is at page LCR. It appears as if some other person has been put in the, some other person was injured. This particular person, Satindra Kalwar, he was not injured.
But that's the different argument. We have to go by the special law.
Your lordship may come to the FIR one
Of the
of the page 3 of the LCR. At the end, your lordship will find page 3. If your lordship goes to the FIR, your lordship will find that it was filed by one Menso Basumatari for the injury sustained by one Latif Basumatari, who has sustained similar kind of injury in his right shoulder. And also page 107 of the FIR.
you may be correct considering that the FIR was by one Menso
And so,
for his brother Latif. But the state accident, he cannot
and
say
the
that
injury is also similar. They are also
maybe But it is a accident involving two vehicles. One truck has collided with a bus.
Yes.
He had, in his affair, he was more interested in the brother, very close to his brother. But the fact of the accident has been given in the affair. I mean, you cannot say that in that accident somebody else was injured. That's not whether you can take it up right now without there.
Now,
Did you take in the as a insurance company? You said that he was not connected with the incident at all. At all. Did you take this point?
no, that point was not taken.
If you not take this point, it is a different kind of a set, as you know. In fact, the admission itself is a very difficult matter. Yes. Unlike in MSc Epic, there's one substantial question need to deposit the entire amount. WC is on a much higher pedestal. Okay, we'll come. We'll consider that.
And claimant. Therefore, the burden has shifted to the claimant to show that he was the employee. He was employed with us. So, as they could not discharge the burden,
Appeal is by the insurance company.
appeal is by the insurance company, but the claim was filed by the claimant. So, it was also his duty to show that he was employed by the owner.
You first have to show that in context with the substantial questions of law frame, the discussion is inadequate, or this the conclusion which have been arrived at, which has been arrived at by the commission, could not have been arrived at any second.
There are
Our role as an appellate court matter under the workman compensation or now the employees compensation are limited role. That is why there is the requirement of framing a substantial question.
substantial and your lordship,
The substantial question of law
yes,
is to eradicate
whether the learned commissioner acted illegally.
illegally discarding the evidence is more on a fact, on fact. So from the fact, if you can make out that the conclusion arrived at by the commission is wholly is a conclusion which could not have been arrived at. Now the commission has made discussion.
Yes.
Now that a mere irregular, mere error in the discussion may not be a fit for unless it is that could not have under any circumstance. He has discarded that part because there was inconsistency. He said that I have not submitted the report he have pointed out.
Yes.
But at the same time, in his deposition, he has said something else which is not.
Regarding the signature,
He said that he cannot write in English.
but he has signed in
He has
English.
signed in English, both in assemblies as in.
Yes. And I'd like to further add two other substantial questions.
At this stage,
Yes.
that notice.
That is permissible, your lordship. There is a decision passed by the apex court in Manika.
But also, here the amount is a very small amount.
Yes.
Could not like verify. You have tried to make out this, but have you paid the amount?
Half has been paid.
Why
That has
half?
been disbursed. There was an order of this court to pay 50% of the awarded sum. 20,
Aren't you prepared to pay the entire amount?
yes,
130
but
something.
subject to that payment, the entire award was paid. Subject to
No.
50. Yes, there is a requirement.
Because before even filing, you have to pay the deposit the entire amount.
I think it might have been deposited, but out of that, 50% has been disbursed.
Released.
Yes.
But you had done your part. You have deposited the entire.
Yes, yes,
If you come to 30, please.
30.
Lord, what your lordship is want to clarify that whether section 30 to comply section 30, my lord, one has to deposit the entire amount.
Yes, right.
But there is a decision of this honorable court.
Just the answer is this.
Justice answer is that was challenged in the appeals court. The appeals court also upheld that. So that is the position, my lord. So therefore, in view of that decision, my lord, the insistence on that section.
No, no,
30.
we are not, the question was not, put, it was put on a different context.
My lord.
Because we, are likely to,
No, my lord, I said,
But-
I'm not on that.
no, therefore, if the money was already deposited,
My lord.
then the probably interest part, we have been absolved of it,
Right.
only for that purpose.
Only thing, my lord, your lordship will see that whether the interest will be from the date of adjudication or from the date of the accident. That will be the question. Is an injury case, and only thing, my lord, there are decision, my lord, if it is a death case or scheduled injury case, that in those circumstances, my lord, interest will be from the date of accident. In any other case, if it is a non-scheduled injury,
Here, what is the direction for,
From the date of order itself.
date for the,
Yes.
that is okay.
then that point is not there. Possibly, in the next case, I am arguing on that.
Date of order.
It's okay, my lord, this point is not there.
Third, Siddhant,
Yes.
Siddhant. Then it comes. We record junior doctor's name or your,
Yes. Lord, yes, sir.
then it comes for the appellant. As third, is appeal under section 30 of the Workmen's Compensation Act. Presently, we represent the Employees Compensation Act 1966 against a judgment at court date 15/10/2008 passed by the Learned Commission, Workmen's Compensation case in WC case number 6 of 2006, also by the aforesaid award, an amount of rupees 1,31,040 has been by the aforesaid, has been awarded to award which interest at the rate of 12% from date of the this court while at appeal by the order it 25 had three following substantive questions from court. It will follow. There are as regards the service, comma, service of notice, application was made in Dainik Town and Assam on 1999 as per an order each 10 of this court got by the order 7 had held that service is complete. The LCR which were called for has also been received. Three doctor, the Learned Council for the appellant insurance company has submitted that though argument statement was filed by the owner of the vehicle, wherein the employment of claimant was admitted, comma, the state owner as CW1 had reposed that the claimant was not under his employment, whom he did not even know. He had also denied some of it. It may be mentioned that as per the claimant's version, comma, he was the cleaner, some conductor of vehicle, namely minibus, with registration number AS09 489, which had met with the accident on 8/7/2005 when he had sustained previous injuries on his right leg, my right hand, and other parts of the body. There was a specific claim with regard to having a fracture of the radius of the right hand and the disability to a loss of earning capacity was determined 25%. The council for appellate has also referred to FIR, which was lost in connection with the accident. Also, the copy of the state FIR, which is available with the LCR, was lost by one Mansu Busmatar on 14/11/2005 in respect of brother Latif Al LATI Busmatar, who was injured. Also, the Learned Council submits that there was no mention about the petition, about the claimant in the state FIR, and therefore the claim itself becomes doubtful. It is also submitted that once the employment itself was denied by the owner of the vehicle, comma, the owner would record upon the claimant to prove such patient, such employer-employee and that owner has not been injured in accordance. Court has noticed that in spite of has noted that in spite of service of notice, none of the respondents have come for contest the claim. That the contentions raised by the Learned Council for appellate have been duly considered and material is put forth have been at the outset of this court take note of the fact that unlike an appeal described by MS Act, which is almost a matter of right, of an appeal under Section 30 of Employees Compensation Act could die to the High Court only on certain conditions and only on availability of a substantial question of law. The entire objective of the legislation is bring a finite of an education of process of education made by employees decide a matter deciding claim raised by an employee or a member of the member of relief member who had suffered an injury of the death by an by being in such a the substantive question of law is is one which for the fact of it, namely the relation of employee employer the judgment passed by the commission has not only considered the efforts of it, but has also gave adequate reason for coming to the conclusion of their purpose of employee employer. In the state judgment, comma, the person of employer which has the in his particular has to take into account wherein the employer has added employment of paid monthly salary and payment of leave allowance. The commissioner has also studied the evidence of court of the witness. The doctor, by referring to deposition of the owner as deductive fund, has however that such deposition of the employment was denied, which that the vehicle was sold the judgment, however, is clear that such sale of vehicle was only at the time of the an accident had occurred in the year 2005. So, the objection, contention raised by the regard denial of substitute and also denial of by the owner has also taken off. However, the commission has based his mind on materials on record after observed that the, that the owner of the bike who had posed as CW has signed his oath in assembly and and there thereby contradicts his earlier that he does not sign it up in English. The consumption has justified while justifying has made the following observation. If you observe that the owner had given contradictory in his deposition and thereby has had lost credit and cannot be relied upon. The legislator had also come from that statement has put his case with the court and other medical doctors with Joe Doctor has raised a point regarding the FIR. It appears that such point was not raised before the London Commission and there in an appeal under the Act, it may not be permissible. It may not be proper to in such which was never raised. In any case, though the FIR was lost by one and so was another with regard to the injury suffered by rather 30%, it cannot be presumed that it cannot be concluded that the state injury constituting a minibus, there was other injury to any other person. In any case, the claim was claimant had proved the police report, but it pertaining to the accident. Were under review of court act and discussion above and out considered uh, there is no dispute with regard to calculation made by the company by reaching the awarded the figure of the awarded amount under the further back and also considering the fact that that it is on which where it all the relevant metrics have taken into account and the object were also property that would for the confidence of also based on fact based keeping in mind the objective of the act and also fact that the awarded amount is not is reasonable and not exorbitant. The capital according to the amount has stated deposit put standard function out of 50% was allowed to come the rest of the amount released put along with interest as per the award.
Obliged.
Let the healthier be sent back immediately.
Whether it can be concluded?
Right. Full
Yes, very good.
half an hour we can
My lord, here,
deputy.
WC. Now, total amount was, my lord, 1,19,000 and odd. And it
Very
was
less amount.
very less, but then what happened here, my lord, your
So we'll
lordship
record your all your content.
no, my lord,
Lesser than junior.
no, my lord,
130 has been dismissed.
everything is,
190 is inviting and
but here your lordship will
will be
find.
very unjustified
Now, how,
if we do not.
how the doctor used to play, my lord, this is the vital thing here.
Was there any injury or
My
are you
lord,
denying the injury?
The injuries are all simple, and what he did, your lordship can see. The
1,90,000
doctor,
1,90,000.
my lord, is very negligible amount. I accept with lordship. Now, the main injury report, which is not on record, my lord, I have
You
checked,
may you just give your points of submission. Just record.
my lord. Now, your lordship will find.
We will not do injustice to you. We'll record all your objections
I'll just show your injury report, the exhibit.
and we'll
3.
very politely.
My lord, I understand, but only thing for where I am,
This matter is specific so that but they not well.
and my lord, the entire amount was deposited. At least the council there could have paid for 50% disbursal. They did not do anything.
This appeal was filed in 2006
Yes.
because of delay condemnation.
My lord, there,
Don't take more than 10 minutes.
my lord, I'll not go into all these things. I'll just
Just,
request your
just
lordship.
give us
Your lordship can see the exhibit 3 from record
first,
page
let us
24.
let us have the fact. Let us
My
see the judgment first.
Judgment your lordship will find from page
It's a
16 onwards.
7-9.
Uh,
7-9.
1/6.
7-9 2006.
Yes, 7/9/2006. Your lordship may skip all these. Your lordship may
First,
come to.
let us see accident part.
Uh,
At page 16, my lord, this claim petition has been filed by so-and-so for the injuries sustained by him in a road traffic accident.
Injury case.
Yes. Then the brief facts, your lordship, may come from there, page 17. The brief fact of the case is that Muhammad Najar Ali was the laborer in the vehicle bearing number so-and-so, owned by so-and-so.
He was a laborer.
Yes. Then loading the sheets of fish, the vehicle number so-and-so was proceeding towards Bokaghat from Hojai via so-and-so. It met with an accident at so-and-so, so-and-so. In the said accident, the claimant, namely so-and-so, sustained multiple grievous injury on his head, left foot, left elbow joint, and on hip joint, and also on different parts of his body. Soon after the accident, the police of Shama police station came to the place of occurrence and registered an accident case so-and-so. And the police sent the claimant to BP Civil Hospital. Your lordship, kindly see, initially he was in the BP Civil Hospital for first aid, and the claimant was treated at BP Civil Hospital, Nagaon, as an injured patient for the injuries so-and-so, so-and-so. Again was admitted on so-and-so for the said injury. He was advised to attend the GMCH orthopedic and plastic surgery by the doctor of BP Civil Hospital, Nagaon. Later on, he was treated by Dr. Dipesh Das at Nagaon. The claimant informed to the opposite party number 1, the employer, about the accident, and he demanded money for treatment, but no help in terms of money received. From the claimant used to get salary so-and-so. The lordship may skip that part. Then the last para, the opposite party number 1 had filed the written statement. That also your lordship may skip. Then page 19, the issues were framed. Whether there is any cause of action. Number 2, whether the accident took place in course of and out of the employment. Then issue number 3, whether the claimant petitioner sustained injuries in the accident. What is the salary? Then whether the claimant is entitled to compensation. Now, issue number 1 and 2, your lordship may skip. Then issue number 3 is important. Your lordship may see that at page 21. The claimant stated in the claim petition and in his evidence on record that he had sustained grievous injury in different parts of his body. He was treated at BP Civil Hospital, Nagaon, as an injured patient for 25 days due to the injury of left foot with ankle joint and head injury, and thereafter he was treated by Dr. Dipesh Das at his private chamber at Nagaon. As per injury report, the claimant has been suffering chronic arthritis at left foot. These are all got up thing. I'll prove it from the evidence on record. Dr. D.
But you're not allowed to argue.
No, my lord, your lordship, kindly see.
Is
Now,
it a substantive question of law?
now the doctor has said,
No, it is substantive question of law.
yes, sir.
There are only two questions.
No, one additional,
One is special allowance and one is interest to date of accident.
no, then another additional substantial question of law is there. The
It
lordship
is.
will find yes.
Where?
Your lordship will find in the order dated.
Whether earning law,
Yes, yes. No,
30%.
yes, regarding that. Now, evidence of the doctor, your lordship will see. Well, it's very alarming, man. And these doctors are, my lord, treated to be a stock witness.
Yes.
Because what is not there on the record, they used to give. Your lordship may kindly see the exhibit 3, which your lordship will find at page 24 on the record. That nullifies the everything. Lordship will find in the cross-examination part, ভৰিৰ আঁঠুত আৰু মূৰৰ কপালত এব্ৰেশ্যন আছিল। তেওঁক লেফ্ট এংকেল জইণ্ট এণ্ড ফুটত চুৱেলিং আছিল। চিভিল হস্পিটেলত পৰীক্ষা কৰোঁতে সেই ইঞ্জুৰি নাছিল। তেওঁৰ ডিচেবলমেণ্ট নাথাকিব পাৰে। মই ক্লেইমেণ্ট এক্সামিনেশ্যনত এক্সিবিট 3 ইছ্যু কৰিছোঁ, এক্সৰে কৰা নাই। বিফোৰ ইছ্যুইং এক্সিবিট 3, proper treatment পালে ভাল হ'ব পাৰে। Now, if these are the things on record, when you are saying being a doctor,
then how can you say that 25% disability with corresponding 30% earning loss? Well, these are the things routine manner they used to give. And then again, he has said osteoarthritis and all that. Now, what are the materials on record? Merely saying one line, you are an expert, that doesn't mean whatever you say, that is the last word.
But we cross-examine the doctor.
We have cross-examined and he has candidly said, my lord, that proper treatment pale phal hobo pare. Now, he has said, by clinical examination only he has given this exhibit. Now, he did not make any X-ray. If there was an X-ray at the relevant point of time, the correct report would have come. That's why, my lord, my submission would be, whatever the amount given, your lordship may reduce down to 50% and that may be allowed. Otherwise, my lord, these are all simple injuries. Somewhere he has said also in his evidence. He said, except injury number 1, all other are simple injuries. The evidence of the DW doctor,
Yes, you are appealing
DW2.
Yes.
for the claimant.
Yes.
What do you say?
My lord, I claimant got serious injury, my lord. His key nerve is sharp, my lord, left leg.
No, those are not see.
And-
See, we do not know what which line will take, but while discussing issue number 3, which pertains to the injury, you just see here the comfort test. Comfort copy of the test.
No.
They cross the PW2, I think it's the doctor.
Yes, PW2 is wrong.
You come to the discussion of PW3. Yeah, have you certified photocopy of the certified copy? Do you have a photocopy of the certified copy?
No. Yeah, photocopy.
Yes, come to the next page. PW3, I mean the issue number 3. It continues on the next page. Yes. First line, sir. The PW number 2, have you got? Cross-examination. Second line. PW number 3, PW number 2, sorry, on cross-examination. Have you got?
Yes.
As stated that he has issued the certificate to the patient or medical observation, and further also that before issuing the exhibit 3, he did not advise the patient for X-ray. In view of the above discussion, I am of the opinion the claimant has lost on. This conclusion does not appear to be linked to the discussion. How he comes to the conclusion that he has lost 30%, even after recording that it was only upon clinical examination, even X-ray was not seen.
I think there is a in the healthcare there is a X-ray plate, my
So he said that I had just clinically examined, I did not advise the patient for X-ray. Curiosity has doctor has evidence of the doctor.
Yes, evidence of the doctor is very clear here.
So there is an X-ray plate.
X-ray plate, but then when it was before the DP hospital, but when he came to him, it was later on. And he has stated in his cross-examination.
Accident was on 24 2000, right?
2003. And he came to him in 2006.
Which doctor? Doctor?
Mr. Das, my lord, this D Das.
Deepesh Das, PW2.
PW2, my lord.
X-ray of 2004.
That is before the BP hospital, the initial stage. He was in the civil hospital first. Then the relevant part is exhibit 16. This is the injury report of the civil hospital. This is not on record, my lord. That could have been given the appropriate light. If your lordship read the cross-examination part,
Of doctor. Cross-examination of doctor.
yes, yes. PW2, Deepesh Das. মই ৰোগীজনক চিকিৎসা কৰা নাই। Civil, CH means civil hospital. Chest ৱালত ফুলিছিল আৰু বিষ আছিল। Abrasion. এই ইঞ্জুৰি নাছিল। The next line also important. Exhibit 16. And this very report is not on record. All other exhibits are there, but this
Where is the exhibit 16?
is not there, my lord. I have checked subject to correction, my lord. I did not find. If we are having this sort of doctor, my lord, this industry will flourish like anything.
He was referred to the hospital department.
A civil hospital recommended.
Yes. PP civil hospital.
My lord.
And orthopedic department.
Yes.
Was the doctor of that civil hospital?
No, no. That he was the best doctor who
Who
could
is
have
this
been.
doctor? Who is this doctor?
PW2 is a
Depends
private
on-
doctor, my lord.
Private doctor.
In a private chamber. My lord, these from Nagaon, my lord, there are 2 or 3 doctors. We just treat them as a stock witness of those claimants, my lord.
They may not be having good practice.
Possibly, my
So
lord.
this is the practice.
Otherwise, this sort of doctor, the flourishing this industry, my lord, they are party to it. My lord, recently,
They are expert in this practice.
this is the unfortunate part. And your lordship has seen recently the Appeals Court has said those fake cases should be pinpointed and there should be given to CBI so that this should not occur. So nowadays, my lord, I can tell you, lordship, at least 80% of the injury cases are fake. And unfortunately, this is all covered up by the people like us, the doctors, the tribunals, commissioners. They all are party to it.
But in this way, I thought this in Madhav doctor, it is the same. But this injury report is of 73 2006.
Yes.
73
17
2006.
How it can be, my lord?
The accident
If
is
the
of
accident,
26 4 2006.
yes.
I have examined the footage.
He may have some idea, but
I have come. The initial accident in April 2003, the injuries were not previous abrasion and lesser, simple in nature.
right.
So that for that injury to end up in a case of disablement would is slightly
My lord,
and that too the report has come in 2006. Has the exhibit 16 been discussed in the judgment?
Lord, I think exhibit 16 is not on record.
No, no. Has it been discussed in the
That I just No, my lord, it has not been discussed.
What is it? side. Look at. Mhm. Yeah. If we assume everything that he had suffered disablement, isn't it required to be given by an appropriate
Actually,
the
my lord,
disablement certificate? Isn't it required to be given by an appropriate authority? Can
Exactly,
a
my
private doctor give a
no, no, no.
It has to be
The-
a board
From the civil hospital, from there itself, he could have procured.
or a board should have been
And
considered.
the board could have been constituted. The private doctor may say many things. And your lordship will find accident on 26/4/2003, and these doctor, he has issued exhibit 3 on 17/3/2006 and has given his report without taking the help of X-ray. Now, how he clinically, how he can say without making an X-ray? And he is not, my lord, orthopedic doctor also, he has stated himself. In fact, this is case falls under section 41D, my lord,
But
not 3.
in his injury report, he says, I have examined following mentioned patient in my chamber on 26/2003
Now, then why, my lord, he
at
issued
around
the
3:30 p.m. following RT on 24/2003, and he gives the injuries. Then in his opinion that today I have examined the same patient in my chamber and found that he was having a particular treatment and this has been signed on 17/2006.
17/3/2006. Why then, my lord, if he has checked him on 2003, 2003 itself, he could have given the report on that date. After 3 years, you were issuing and you were saying so many things, and there is no X-ray report. You may be a doctor, but there must be some basis of coming to all these findings.
But he's a medical and health officer, government.
My lord, that's a different issue, but then as a private doctor, he has issued all these things. Whether he can do that,
He's a gynecologist.
I have seen that.
He's a OPST and gynecologist.
Yes.
Actually, my lord, he is wrong advice, my lord, given, my lord. As per judgment, my lord, he was referred to GMC orthopedic and plastic surgery. Instead of going admitted GMC, my lord, he has treated in the private sector. Wrongly.
Yes, what you say?
My lord,
Materials are not
small amount, my lord.
small amount, but materials are not
Small amount, my lord.
expiring in confidence. The
Small
materials
amount,
would have
my lord,
expired.
1
Instead
lakh.
of confidence, we don't have
1 lakh.
that in it. Last case we have seen our small amount. Materials are there. Little bit of wear and tear is okay.
Lord.
But here,
Record to
that's what you.
My lord, lump sum basis, your lordship may
How much was the amount given?
1,19,000.
19,
1 lakh 9.
19.
19.
One.
My lord, it's a case of your lordship has seen simple injury. This doctor himself has said, barring number 2, all others are simple injury. So therefore, my lord, can I propose, my lord, from my side? The 75,000 will be off. I'm not bargaining here, my lord, seeing the nitty-gritty of the thing. And in fact, my lord, my main grievance is against this doctor. He should be called here and asked why he did it, and appropriate punishment can be imposed.
Challenge me cannot let us think, cannot alter it if we get very less. But we may say something.
My lord, I'll leave up to you, lord.
So the amount is you are right. Appears to be made out.
Anyway, your lordship will come across many of cases like this.
We'll have the judgment.
My lord. My lord, just 1 minute in regard to earlier case. Whether we have deposited entire amount before the
That you are not aware.
I'm not sure, my lord. So 50% we have deposited before this honorable court, and it has been disbursed. So my lord, there your lordship may
Then we'll make both the if the entire amount has been deposited, the question of interest may not.
my lord.
Then 50%, 12% will be on 8%.
Oh, that's
First process. But 16, unfortunately, is not there. 16 should
yeah,
have been
it's
there.
not there. I checked.
Yes, press date, put must. Any matter where interim order is given today.
Obliged.
That is out of record.
Item number
36.
first order. 36. When did you file IE?
My lord, 19.
First of last.
Lordship,
36.
Lordship, item number
36, sir.
36, both are late.
IE.
I have my lord, 27,
Oh, IE has the number.
Yes.
2730.
2730. 40.
I don't know.
No, my lord, my lord, this is came to me, my lord, subsequently, my lord,
Your board. That fit. I think the yes, filed on first of September. So the on Friday along.
my lord,
On next
Lordship, item 58, it is just a correction of the last page only, two lines.
Can it be on 27, my lord? That matter, my lord. 36, 37. I am there, my
My
lord.
lord,
Can it be on 27? 27.
Monday. Monday after
Yes, 27.
27. On 27. Yes. Item number
Item 58, Lordship. Yes, supplementary, only one matter is in supplementary.
don't have
Lordship, item number 57, Lordship is listed for the first time. Notices may go, Lordship. There is a delay of 357 days, Lordship. Item number 57.
Madam, we'll take up this matter. We said on the urgent matter. Don't take it
Lordship,
indulgence.
it is urgent. Lordship, Bakija proceeding has been initiated, Lordship.
No, we don't have the time. We're only saying where interim orders are there.
Lordship, actually, the Bakija proceeding has been
Doesn't
initiated.
matter. I have to see it after the time. Fix.
No, Lord.
Get it tomorrow with the listed. Don't make unreasonable prayers like this, madam. Yours is not the only case.
No, Lordship.
Is yours is the only case you're listing?
Lordship, actually, in the lower court, they require order of this court, Lordship. That this case
We are
is,
not ordered. We'll do our work within the time prescribed. If you say that we don't have to attend the reference, ask the court not to have any reference.
no, Lordship, that is not.
What kind of prayer is this?
Sorry.
We'll have it tomorrow.